Good afternoon. This is Camille Crary. I am the Director of Legal Services and Policy at the Ohio Alliance to End Sexual Violence. I am so happy that you have joined us today. We at OAESV have put a substantial amount of time and energy into really understanding the fluctuating nature of Title IX over the past several years. And as I mentioned in our last webinar introduction, this has felt like a very long time coming. And so we are not happy with most of the outcomes in the final rule, but we are relieved in some respects to be at a point where we can explain them and have some finality with what has transpired and what may happen. So today we have the entire legal team, which is wonderful. Chelsea Daniel, our campus legal advocate, is here today. Becca Getson, OAESV's legal advocate. April Carter, who works for the Ohio Survivors Legal Assistance Clinic, which is in-house at OAESV, is here. Kendra Roberts, who is also with the clinic, is here today, and I am also here. We will be going through, this is the second of a three-part series. If you have not had a chance to listen to the first webinar, please feel free to reach out and we can send you that registration link and you can access that as a recording. Just a few technical points. We will be, as I mentioned, this is the second of a three-part series. So in the first webinar, we spent about an hour and a half on content and then did a half an hour of questions. Today, we will spend an hour and a half on content and do a half an hour of questions. And then on June 1st, we will spend a significant amount of time doing Q&A and talking about best practices, as well as walking participants through the best practice resources that we have put together. So we are currently working on a roadmap, which is a significant project that we started developing during the notice and comment period, and we'll be providing our recommendations for best practices through that document. So today, you will notice that we are not starting at the beginning. We did that last week, so we will be starting from where we kind of left off. And Kendra discussed last time the requirement that a formal complaint be placed or be made at a campus. And so when we use the term campus, we're really talking about not K-12 institutions. We're talking about tech schools, college campuses, not just the traditional four-year college, but anything that meets the regulations definition of a campus. So as we're going through this right now, Kendra is going to pick up in the formal complaint process. And I want to note that this really is just about campuses. She will highlight when she is talking about K-12 because the K-12 provisions are rather different, particularly with regard to this provision. So if you have questions, Becca Getson will be monitoring the question box. And the way that we typically do this, just to make sure that we are getting through as much content as possible and allowing folks who participate to formulate questions throughout, is that we, like I said, respond to questions at the end of the webinar. So we'll do 90 minutes of content, 30 minutes of questions. So there is a question box that you can type your questions in. We will compile those and Becca will ensure that we get to every question that is posed as time allows. So with that, I'm very excited to hand over the mic, the figurative mic, to Kendra Roberts, the LAV attorney with our Survivor Legal Assistance Clinic.
Hello, everyone. So as Camille said, last week we kind of talked about that time period in the Title IX process where a survivor has considered whether or not they will report an instance of sexual harassment, or of course another person could report their knowledge of an instance of sexual harassment. Kind of talked about what sexual harassment is, all the different types. And as a reminder, I'll use the term throughout here of sexual harassment because that's kind of the umbrella term for all the different types of sexual violence that fall under the definition of sexual harassment in Title IX. But keep in mind that I'm not just talking about what might immediately come to mind when we talk about sexual harassment. You know, stalking behaviors, verbal threats, and degrading language. So last time we talked about this portion of time where there's a complaint filed or submitted to the Title IX coordinator, and what happens around then, things the school can and can't do at that point, and then the decision on whether or not to pursue a formal complaint, which of course, as we talked about last time, kind of launches us into the actual Title IX investigation process. And so I'm gonna go backward just quickly. I do want to just keep at the top of our minds again. Last time we talked about some themes we're going to see throughout the new rules, and you're going to see these themes pop up probably even more prominently today as we talk about the grievance process. That is the actual process that will take place during the investigation, during a hearing, and during the appeal for both parties. And the written rules regarding all of those things are quite specific in the new rule. And again, so in that language, you're going to see these themes pop up throughout. I point this out because we need to be on the lookout for these things as attorneys and advocates and as survivors support. Because when we see these things, as we're looking at school policies in helping individual survivors, I think it's important to identify these themes as we're reading the language in not only Title IX, but in the school policies we're going to see in the fall, because we need to kind of alert, red alert to these things, and then think how to strategize through them or around them. Some of those strategy type practice points we will give next week, but I'll mention a few throughout today. So some of those themes, like we remember, is this idea of cutting the college kids some slack, right? Kids will be kids, boys will be boys. Locker room talk is locker room talk. We kind of see this theme throughout. And what connects up to that is this idea of the importance of free speech. Again and again, we're going to see mentioned language regarding the importance of the First Amendment. There will be declarations about how the First Amendment applies to Title IX, which I question only because we know that the First Amendment is part of the Constitution, which presumably applies to every law and regulation. But they really make a point to stress that here, again, to make the background of free speech, and free speech is not sexual harassment, right? This is that you may think that this language is objectionably degrading or unreasonable, but hey, if it's given in the context of free speech, you can't call it sexual harassment, and therefore you can't punish it, right? We're going to see a lot of that. We talked about some of these increased standard for what is harassing language. We'll talk today about retaliation and how that fits in. And then again, we see this theme of the shift from punishment to process, right? So they want more and more process, more and more very specific requirements that we're going to see today in the grievance process. And it seems as though each of those steps are an attempt to shift away from punishment. We see the punishment not being available to us in any respect preemptively, so not until after a definite finding of responsibility, and probably arguably not until after the appeal process has finished. We'll talk about that. And so, we see the supportive measures that can only be geared at helping a single party have equal access to education. They can't be considered punishment in any way. They can't be punitive in any way, no matter what the nature of the offense is. And so we're going to see a lot of that. And then again, we're going to see a lot of language about this responsibility regarding claim of sexual harassment cannot be presumed due to gender. I think the unwritten language in this is that a respondent's identity as a male or as a school athlete or as a person of privilege, given socioeconomic status or whatever it may be, cannot be considered in the assumption of whether or not they did or did not do these things to the complainant. And so we're going to see respondents' attorneys use that line, I would presume, in every single case where they have something, they are bringing something forth to complain about. So let's move forward then. Let's talk about the formal complaint a little bit again. As you'll remember, this is that official document that has to be filed and signed by the complainant that tells the school, let's launch the Title IX process. Let's launch the investigation. When the school receives this one, and as you'll remember, it isn't necessarily simple to file this formal complaint. And so you're gonna have to work with survivors to know precisely what needs to be done in the individual school in order to consider that formal complaint filed. It's likely going to be only one document, so it's going to be a specific form that needs to be filed. It's probably going to be need to be signed in person by the complainant, and nothing else, no matter how specific, is going to count as a formal complaint. And there may only be one way to submit that, whether it be in person to the Title IX coordinator through a specific to a specific email address, or through a specific website portal. So that's going to be different by institution, but they only have to provide one way. All right, so once that formal complaint presumably is properly filed, the school is going to have several responsibilities, and these responsibilities are going to be, of course, to both parties, right? So once that formal complaint is filed, they have to provide written notice to both parties of the complaint, right? So, hey, there's an allegation of sexual harassment and we're going to investigate it. That notice needs to include lots of things. Presumably, this should be the first time that the respondent has notice of the complaint. So when the report itself is filed, the rules do not specify that the school needs to notify the respondent of the allegations against them. The only thing required at that point is that the school discuss the complaint with the complainant or the, quote unquote victim, and that they offer supportive measures for that person. And they talk them through whether or not that person wants to file a formal complaint. So we should be able to use that little free space to the advantage of survivors, presuming that the schools follow that guidance. And so when we have survivors that are unsure whether or not they want to report, or afraid of retaliation, afraid of intimidation on behalf of the either the respondent or other students, we can hope that we can guide them toward reporting just to get some information, or just to receive some supportive measures if they may not actually want to continue on with the formal process. We are going to need to be on the lookout for that, though. If we see school policies that are stating that respondents are going to be provided notice upon complaint upon report rather than the formal complaint, we need to point that out, that's not actually what the rules say to these schools. Okay, so once this formal complaint is filed, school's going to provide all this notice. They have to tell both parties, and particularly the respondent, what allegations were made and what facts constitute sexual harassment. So this is where we're going to see they're going to have to use that precise language of the definition of whatever type of sexual harassment it is, and show how the facts that are alleged constitute that, or could constitute that if true. This is going to be very specific, and probably means that if the school can't quite do that, so if the school can't quite match each element of the definition of sexual harassment to the facts that are alleged, that they probably could use their discretion to dismiss the complaint. So that means that if the requirement for, let's say, the requirement for sexual misconduct is that there was a lack of consent either by force or by intoxication, and there is an instance where they no facts were given that demonstrate that there may have been force use, or that that the complainant may have been intoxicated. Even if an investigation may lead to that, if there isn't on its face that possibility, there's a chance that school's going to dismiss that. So if you are helping a survivor file an initial complaint, that may be an important reason to get an attorney early who can help them kind of fashion those complaints so that each element is met, and maybe we can avoid that dismissal. Again, the specifics, if the complainant is able to give a date and time of the harassment, they're going to have to give that to the respondent. They're going to have to talk about whoever the complainant mentions as being involved, and that probably is going to include witnesses. They're going to have to include a statement to both parties that there is a presumption of innocence. That has always been true in most every school policy that I've seen, but they make sure to hammer it out here. They're going to tell both parties that they are entitled to an advisor, quote unquote, of their choice. So if they have a person, either an attorney or whoever they deem fit to be their own advisor, they can bring one person as their advisor. They will inform the parties that if the parties don't have an advisor of their own that they've chosen, the school will provide a advisor of the school's choice, but that person will only have the role of conducting cross-examination. We'll talk about that a little bit more at length in a little bit. They will tell both parties that they have the right to inspect and review certain evidence. So obviously this leads us to, what does that mean? We know that probably means that, and this is probably true in most policies you've already seen, but there's not going to be right to copies of everything, physical copies. And probably it is true that you probably have run into cases, most schools I see, at least the larger schools with more resources, seem to be providing the evidence, providing the investigation reports and evidence submitted by both parties. They seem to be providing that to the parties online via like a box account or some sort of restricted login account where the student or the advisor can log in. It's only available during this investigation process, and can read and view the evidence, but cannot print it, cannot copy it. Presumably the right to inspect and review does not require that to occur. So schools could provide that online access, which is a little bit more simple than having to go to the Title IX office and physically sit down and look at it. But also, I think it is true that schools could require that. So schools could say, sure, you can come see the evidence, but you or your advisor have to physically come, sit in the Title IX office, look at it. You can take notes, but you're not going to be able to take pictures of it. You're not going to be able to make copies of it. You're not going to be able to leave with it. And then this idea of right to inspect and review certain evidence. There's no real clearly defined definition here of certain. So it seems as though schools are going to be able to define that themselves. That may mean that some schools say everything. That probably will mean that schools will define that as relevant evidence, but then it's going to be up to the individual schools to define what evidence they determine to be relevant in individual cases, which we of course could see being problematic really for one or both parties, because if a party of course submits evidence that they think should be considered by the decision maker, and the school determines that certain evidence is not relevant, shouldn't be considered, then it probably isn't going to make it past that kind of gate check. The school also needs to provide both parties with information regarding the code of conduct and false statement consequences. We're going to talk about that a little bit more later. And then they also need to provide information on the informal resolution process and how both parties could volunteer to engage in that, but it would require both parties doing so voluntarily. And then they also need to give them information about all of their rights, right? They have a right to a process free from discrimination based on sex. What's really interesting here is they include the language of with respect to credibility determinations. We are going to see this used by respondents' attorneys, I think, over and over again. And here's how. Again, this is going back to the idea of, for example, just because the respondent is a male college student doesn't mean that it's probable that he, you know, had non-consensual sexual intercourse with this college-age female because she says she was too intoxicated to consent. So we're going to see this right to the process free from discrimination with this credibility determination over and over again, language by respondents' attorneys when they have a concern about any decision, I think, that either the Title IX coordinator, investigator, or decision makers make. So we should expect to have to respond to that that use of that language. And then finally, this is new for the most part. The respondent cannot be interviewed upon receiving notice. So once the respondent receives notice that there's been allegations filed against them, the school cannot immediately interview them. They have to give them sufficient time to prepare for their initial interview. The schools are obviously going to individually decide what that sufficient time to prepare is. Later in the rules, we're going to see some places where there's a requirement to give 10 days to respond to things. So I think there is a chance that schools will adopt that here. And so respondents could have probably up to 10 days to, you know, prepare themselves to respond to an allegation. Obviously, that's problematic, right? And we know why. Similar to when we think about, you know, the incident that comes to mind for me is there's a lot of pushback in the public when there is a police officer involved incident or shooting, and that person is often given kind of a moment of leave before they have to make any statement, that officer is, and or that department is given time to review that body cam evidence or audio recording before submitting it or before discussing it. And of course, the concern is that this gives them time to kind of either make up a story or make sure that details one person provides matches the details another person is going to provide, kind of clear up any inconsistencies that could make it seem like they're not being truthful, right? Also, the concern, of course, is that they can warn others, hey, you were a witness to this, say you didn't know anything, or ignore the school, or even just the head up of this might be happening, could affect the credibility of the statements those people ultimately give. It's going to give them time, presumably, to destroy evidence if there is any that can be destroyed, text messages or whatever it may be that the school may ask for. They can, you know, get rid of the ones they think may not be so helpful. This is a little bit problematic. I understand the need for it. It's kind of that providing that due process, give them time to maybe speak to an attorney or to just wrap their head around the fact that they've been accused. But I am concerned that if that sufficient time to prepare is too lengthy, it can be manipulated. Okay. The school does have the right to emergency removal. So that is when a formal complaint is filed, if the nature of the allegations are so severe, it's a really severe instance of violence. It's instance that really the school is concerned about putting either the complainant or other potential complainants or just the school community at risk. Maybe there was a weapon used. The school can, so it's within their discretion, decide to remove the respondent during the investigation. But they have to make these findings, right? They have to find that there's an immediate threat to anyone's physical health or safety. The anyone's there is good because it doesn't necessarily have to be the complainant that is threatened, but that immediate threat is important because if they can't determine that something could happen instantly, then they probably aren't going to remove them. This has always kind of been the case in school policies, but we've seen a little bit more lax language before. I think this is going to happen obviously rarely. And what's also important here is that this emergency removal option for the school The language indicates that it occurs at the time the investigation is launched, so after that formal complaint is filed, which presumably means this is not at the time when the complaint is received. We would presume that this right also exists, of course, that the university or other school has the right to remove a student who poses a significant threat to others, even if there hasn't been a formal complaint filed, just upon receiving the report. But the new rule language really only specifies to at this point. So if the complainant, for whatever reason, decides not to go forward with the formal complaint, the question remains as, can this person be removed? And I think that the answer is, if they are, there's going to be a lot of pushback from that person or their attorney. And then, of course, if the respondent is an employee, so say a professor, they can be placed on administrative leave during the investigation under the Title IX policy, but obviously they may have other rights under different laws that protect them from that. All right. So, like I said, actually, I'm going to go back. Becca, do you have any, let's go this way. Becca, before I move on, do you have any comments on an advocate's perspective around this formal complaint?
Sure. So yeah, there's a couple of things that kind of jumped out to my attention while thinking through it as an advocate supporting a survivor. I think one of the things that I would highlight working with a survivor is also the good parts about the formal complaint. I know prior to this, there would be like accidental reports where someone would report to an RA who was also a friend. Someone would write about it in a paper. So I think kind of that can be something that we can kind of look at and kind of be supportive with a survivor about like choosing when to start. With that being said, there's some good and bad that goes along with that, which also means that just telling a professor is not going to initiate this, right? Just writing about it isn't going to initiate. So if someone, we need to be very clear about, if someone wants to move forward on something, they are going to have to go talk to that timeline coordinator, going to have to get that formal complaint started, and being very clear about that, right? So just going and talking to an academic advisor or a counselor is not going to initiate this. So just being very, very clear about what that looks like and what that means. Also reminding about that presumption of not responsible and what those time periods look like, right? So as Kendra was talking about, giving that sufficient time to prepare, a survivor, once they do that formal complaint, they might be ready to go, right? Like we want that formal complaint and we're gonna get the process started. It might feel like a huge wait time then, depending upon what the school's looking at implementing in terms of that initial time frame to get that initial interview. So if, as Kendra said, they implement some kind of 10-day, that's 2 weeks, right? And that is a very long time for a survivor to not know what's going on, right? So they do the formal complaint, make that decision. So that's a very, very different thing also from the criminal world. So if you're used to working in the criminal world where police can talk to someone without giving them that kind of notice, this is very different from that. And talking through a survivor, what is the best route in terms of reporting to who, when, right? So just thinking through that. And then the last thing I wanted to make sure and touch upon was that physical threat piece that Kendra talked about in regards to when someone can be, removed from the school. They put an emphasis on that physical health and safety. So while working with the survivor, I know it can be difficult for them to kind of talk about what those fears and concerns are. If a school doesn't know that someone's in any kind of physical danger, there's not much they can do about it up front, right? So if there is that concern about physical health or safety threat, they're going to have to tell someone about that, right? They're going to need to tell the school about it, which I know can be really hard, but making sure the survivors are aware of that, so that way the school can make that decision up front and know what's going on in that case. So that's just a couple of the things I want to make sure and highlight when working with a survivor, kind of from that advocacy side.
Thanks, Becca. All right, let's see here. All right, so we're gonna move on to the grievance procedures. And like I said, these new rules, one thing that is unique about these new rules is there are some really specific step-by-step procedures and then some just general requirements about the process the school takes through the investigation and hearing and thereafter that we haven't seen subscribed before, like in the previous guidance. Schools have less freedom to kind of circumscribe their own policies. Schools can and will have their own policies, and they will have individual, we're going to see each process is a little bit different. There are going to be details that some schools require, others don't, and we know the timeframes are going to differ, but we know also that every single school policy is going to include all of these things. And so they're going to be, number one, lengthy, a little obtuse, maybe hard to understand, particularly for survivors. And so it's going to definitely be worth going over. Number one, as supporters of survivors, becoming familiar as much as we can ourselves with the procedures at an individual school, and then walking them through that, because they may be a little, they're going to be lengthy, they're going to be confusing, probably. All right, so grievance procedures, what is required? All grievance procedures, so the step-by-step, what happens when, must be written and must be available for the parties to obtain. It also must be available to the public upon request, and it has to be on the school's website if they have a website. This is all pretty, not unusual. We all know this to be true. What we're going to see here, though, is if there's any little piece, so if there's any little step taken, any little decision made by the school that is not written in the procedures, the respondent attorney is going to use that to their advantage to say that the school cannot do that, should not have done that. And of course that, they're going to try to appeal on that piece, and they may succeed. Obviously, as supporters of survivors, I think we use this to our advantage too. So if some benefit is given to the respondent that's not explicitly written in the procedures, I think that it is clearly within our purview to argue that it shouldn't have been able to happen because it wasn't written. All the provisions of grievance procedures, so individual school policies, must apply equally to both parties. Again, this has always been true before, but the new rules, again, make that really explicit here. And then it's important to add, of course, we might have talked about this last time, but schools can always add provisions to their procedures, so they can add requirements in addition to the ones that the new rules subscribe. But of course, they have to be applied to both parties. We may see less of that, just given that these procedures are so specific. It may be true that schools don't take the time to add provisions because there is specific language they can use here. And it may be worthwhile to advocate for some provisions as we begin seeing things happen in practice. If they are not included, and to remind schools that they can absolutely add that language. They just have to make sure it applies to both. All right, so what are some of these required grievance procedures? Here are some of the general ideas. These aren't the kind of step-by-step hearing process yet, but these are the kind of overall, all procedures have to do these things. So again, they have to treat the parties equally. The only exception, of course, is after a finding of responsibility, then the school can provide the complainant with remedies, which are kind of those one-way measures that can be punitive. That's the best example is a one-way no protection order, a order that the respondent has to stay away from a specific building. Those can be given only to the complainant after the respondent has been found responsible, but not in time before. It's required that the decision makers perform an objective evaluation of the evidence. You know, that means they can't be biased, right? They can't be, they have to be completely neutral going in. Look at the evidence as it is presented. They can't add any more or less information or perception to it. For whatever reason, the rules include this, including both inculpatory and exculpatory evidence. That is, of course, evidence that either makes it more likely or less likely that the respondent did the thing the complainant is alleging. I think we use this to our advantage when we can, and if the school does try to say that some evidence is not relevant for whatever reason, you can try to point to this language and say it is because it's inculpatory this way or exculpatory in this way. Credibility determinations, again, we're going to see this, cannot be based on a person's status as the complainant, the respondent, the witness. And, you know, I think this goes back to and as the gender. Troublesome here to me that there is no mention specifically for, you know, the things we would like to see here, right? About the person's status that shouldn't create any bias, the race, the privilege, the sexual orientation of that person. But we don't see that. So I think the intent here was that just because someone is a respondent, because someone has alleged they did this thing, the school shouldn't assume it's more likely that they did than they did not. All decision makers and Title IX employees must be trained annually and must be free of conflicts of interest. This conflict of interest piece appears again and again throughout the new rules, and I think that we are going to see respondents and respondents' attorneys using this language to their advantage as well. I think that may come in the form of, if you haven't already seen this in cases, what it will look like is kind of some sort of filing to remove some person, some school employee, the coordinator or decision maker, a panel member, from the process because of their alleged conflicts, and they're going to try to use a really broad interpretation of what a conflict is. For instance, I have seen respondents' attorneys attempt to remove panel members from the panel because of a several-year-old Facebook post that that demonstrated some support of women's rights. And so the allegation there was that this person couldn't be, that had a conflict because they couldn't be unbiased because they supported women or women. It did not work in that case, but I think we will still continue to see these allegations to at least delay the proceedings, if not hope to disrupt them entirely. And then I think we'll see this allegation of conflict even after findings of responsibility as well, in the hopes that they can reset the process, do it all over again because there was this. Okay, also, good news, everyone in the process, so the Title IX coordinator, the decision makers, everyone involved, has to be trained annually. That's great. And what's also great is that we get to see the training that they receive. What's maybe not so great is what they think is important for these people to be trained upon. They have to be trained upon the fact that they can't rely on these sex stereotypes. Again, we're going back to this, right? Just because this alleged sexual assault occurred by a male student at a fraternity house during a large party in his bedroom does not make it more or less likely that it's true. They have to, these training materials have to promote impartial investigations and adjudications. And we're going again back to that impartial piece. Must include training on the issues regarding relevance. Again, here's how you throw out evidence. If it isn't directly relevant, you don't have to consider it. And so again, it has to be posted on the website or available. So we will be able to see these things. What is glaringly missing from this training material that has to be provided is any mention of the effects of trauma on a survivor, you know, any sort of survivor-centered practices, and that's That's supremely concerning to me, because if it is not in that list, it's unlikely a school is going to be apt to add more work, more topics that have to be covered for themselves, if it isn't in this enumerated list. Obviously, the other question there is who is providing this training. My hope is that we will be able to tell that from because it is posted and available, but there is no indication in the rules precisely who is doing that. Okay. Becca, do you have anything here before I move on to the some more procedures?
I think the biggest thing I want to make sure to point out is that there's a lot of talk, and a lot of the regulations talk about being treating the parties equally and what that might look like, and offering the same thing. But just because things are offered doesn't mean that they need to take it, right? So if one person does want to change classes, that doesn't mean that both need to, and that all those kind of things that they need to be offered and available. I will say that may not feel equal, though, right? So just being very cognizant of that fact, that even if everything's being offered equally, and it may also feel a little unjust for a complainant to receive something that is the same as the respondent. So just being aware of that and what that might mean, and that kind of goes back to what Kendra was saying about in terms of that trauma piece when someone's experiencing that. It might be helpful to obtain access to that training material so you know what the decision makers are receiving, you know what they've learned about. Also knowing when they received it could also be helpful too. So if a decision maker is part of a group of decision makers, so let's say there's a panel of them and this person received training in August, but they don't actually hear a case until April, that's quite a ways away from when they had received that training. So knowing that can also be helpful in terms of thinking through what would be helpful in terms of reminding them about, or what information is going to be at the forefront when they're thinking through things. So just a couple different things on that in terms of what the survivor might be expecting and what's available to you to help prep for that.
Thanks, Becca. All right, we are going to move on to a few more requirements of the procedures. None of these are groundbreaking, but there needs to be a presumption of innocence. There needs to be reasonably prompt timeframes. So the school's going to define the timeframes within their own school policy, but they have to be reasonably prompt. That arguably should benefit both parties. Neither party wants it to drag on and on and on. However, sometimes maybe for some reason they do, and there is a means of requesting delay, obviously, to show that good cause. Each school is going to define that good cause. I would presume they're going to be fairly liberal in that for both parties, asking for a continuance in time at least once or twice. The school procedures need to provide a description of the range of outcomes. So we're going to want to advocate for an expansive list of these, or some really broad language, something along the lines of anything else the school deems sufficient to address the nature of the crime, or whatever it may be, to keep everyone safe. Because I think that if there is a specific range of outcomes, you know, a finding of responsibility, a finding of not responsible, and all these different disciplinary measures that can be taken, all of these different remedies that can be given to the complainant. If there is a really long list of those things, and the school imposes something that is not specifically on that list, I think we are inviting the opportunity for the respondent to say, whoa, 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 you can't do that to me because you said these are all the outcomes, and it's not precisely on there. That's why we kind of want this, at least maybe one umbrella provision that leaves some discretion to the school, or we want that list to be real expansive and include all of the possible things that a survivor may want. They also needed to provide a description of the range of support measures. So what are all the different types of support measures that could be provided to either party, academically, with housing, you know, with what kind of counseling measures can be given. And I think the same is true for this range. We're hoping for some broad language or a really expansive list. All right, so under the new procedures, the standard of evidence, so that means what the what needs to be shown in order to find a respondent responsible for one or more of the allegations. You probably all are pretty familiar with the preponderance of evidence standard. Most schools use that, and that's kind of that probability, right? More likely than not, 51%. It is more probable that this happened than that it didn't happen. Schools can still use that standard, but they don't have to. They could also use the clear and convincing evidence standard, which is a little bit harder to meet. There's process which state which of those two standards will be used in all sexual harassment proceedings. This is important because whatever standard they decide to use in these sexual harassment proceedings does not have to be the same standard they use in other proceedings, for instance, in code of conduct violations and things like that. It only needs to be used in these Title IX cases for sexual harassment proceedings. Now, it does need to apply to all respondents, whether they're a student, whether they're an employee, whether the allegation is non-consensual sexual penetration or sexual harassment through objective words being used. Does not matter. If it's a sexual harassment proceeding, it must use the same standard across the board. And then again, that preponderance of evidence we might be more familiar with is that a little bit simpler to meet. The clear and convincing is higher. So here we can see that that preponderance of evidence there is right over that if that line there shows 50%, it's right over that, anywhere over that. 50.1 meets the preponderance of evidence standard. That yellow area is where we see the clear and convincing standard, and it's pretty wide, right? So the school may decide that they find clear and convincing evidence to be real close to that red area. They may also find that it's closer to that preponderance of evidence area. Where I put that arrow, I think, is where we would hope it would land. But again, where the words clear and convincing are, maybe more likely that they think it needs to meet that threshold. It's an amorphous threshold. There's no, real definition here. But all of that is to say that if the school does apply clear and convincing evidence standard to these hearings, then it is going to be more difficult to prove that a violation of sexual harassment, sexual assault, sexual violence occurred than it would have been under the preponderance standard. The beyond a reasonable doubt standard, of course, is what you may be familiar with in the criminal context. The clear and convincing standard, if the schools choose to use that, is less than that. That's like a, I think in law school they tell us that's a 95 to 98% sure that this thing happened, which is a little bit discomforting. I would hope it was maybe 99 if I were facing some, but they just have to find some reasonable doubt there. It's less than that. It's not that high in clear and convincing, but arguably it could be approaching that, depending on where in that yellow area the school decides to define clear and convincing themselves, or I guess those individual decision makers, because there is a subjective nature to this. It's going to be up to the individual decision makers on how they apply these standards to the facts. All right. Becca, do you have anything more to say on the standard of evidence for advocates?
I think the only thing I'd point out there is, once again, that reasonably prompt and also standard of evidence, those are all terms that are going to need to be really explained. That's also going to be dependent upon every single school, right? So what someone determines as reasonably prompt is going to be very different. The standard of evidence, that is a difficult thing to wrap your brain around. So making sure to really explain that, what that looks like. And if you're working with multiple schools, making sure you become very familiar with whatever standard of evidence they're using or what that reasonably prompt time frame looks like for them. So that way you can provide hopefully as much information to that survivor and give them as much information as possible so that they're feeling as comfortable as one can get in this kind of a process. Also reminding them that there are other laws that can come into play. So I know we talked about removing someone from a school, but there's also, if they're an employee, there are other laws that come into play there in terms of what a school can and can't do. Sometimes, I know when I've worked with students before, they kind of think of institutions as being like these all-powerful entities, right? And schools don't have that kind of power to just remove someone or to do something immediately. There have to be processes involved. So as much as you can remind them of that and know that in advance, as much prep work about that is beneficial, and providing as much information about that to the survivor can be helpful in terms of having them know and feel comfortable and knowing what that process is going to look like.
Thank you, Becca. Okay. Some more requirements of all of these procedures. This one is a little strange to me because I would presume this is a given, so I'm not 100% sure what the intent here is. I can tell you what I think it may be and how we think we might see it used, but it seems duplicative. So privileged information cannot be used in an investigation. A school cannot, I don't know, I think that should be used, evidence protected by privilege. This is an example is the information provided to an attorney from their client, doctor-patient confidentiality, things like that, unless it's waived by that student. We've always known that to be true. That's why the privileges exist. So I'm not 100% sure why it was important to include so much language here about it. Also, what remains to be seen is the school cannot use evidence in a hearing that's protected by privilege. That waiver language is missing from that line in the language. I would presume it to be true that, let's say, a complainant wants to introduce their therapy records to indicate that they began therapy right after the event and that they were diagnosed with post-traumatic stress disorder because of, presumably because of, or right after the assault that they endured. I would presume that if they have waived that privilege, they can choose to introduce that into a hearing, though some schools may say if it was originally privileged, we're not considering it in the hearing, which is something we may need to advocate for if that's what that survivor wants. What it does mean, though, of course, is that schools can't on their own demand that the school counseling center provide them with records of a student having gone there for therapy or what was discussed. The procedures have to include a right to appeal. I'm going to describe the appeal process in just a minute a little bit more, but both parties have to be given this right to appeal. Institutions can provide basis, so reasons you can appeal beyond these, but these must be provided. I think, again, like some other instances in the new rule, because there are 3 enumerated here, I think it's likely that these will be the 3 we see in most all policies, rather than the school taking the time to add grounds for appeal, but they may. So again, that's going to be individual to the school, so check that. And here are the reasons a person can appeal. Some procedural irregularity affected the outcome. That means that anything in all of these procedures, any of these requirements, what should have happened didn't, and that it affected the outcome. So it isn't going to be enough that some little thing went a little bit differently than what's prescribed in the writing, but that it did affect the outcome, right? So the finding of responsible or not responsible would have been different if the procedure would have been followed in the way it should have been. One thing I think we're going to see here, like I said earlier, is this requirement that credibility determinations not be based upon gender or status. I think in the event that a respondent is appealing a finding of responsibility, we are going to see the argument that somehow some decision maker, the coordinator, whomever, did determine that the respondent was less credible or that the complaint was more credible because of their gender or their status as complainant, whatever it may be, and that is why they need to redo this look back. So it might not actually be, it might be something more amorphous like that. It may not be, I didn't receive a written copy of the investigation report. New evidence that's not reasonably available at the time of the finding or dismissal. Remember that there's 2 times that this appeal, this right to appeal exists. It's at the dismissal stage. So when the institution is determining whether or not they will dismiss the complaint altogether or parts of it, either at their discretion or through a mandatory dismissal, at that point, both parties will have a chance to appeal that decision to dismiss. And then again, it's available to both parties at the end of the process after there's been a finding of whether or not the respondent is responsible. And the new evidence that they're presenting has to have not been reasonably available at that time. Reasonably available is another one of these things that's going to be defined by the school in individual cases. And then again, we see this conflict of interest. The conflict of interest by a coordinator or decision maker affected the outcome. We're certainly going to see this used in any way that a respondent can try. Though again, remember, each of these grounds also exists for a survivor. And so if the outcome of a hearing is not what the survivor wishes it would have been, all of these bases will be open for them as well. Okay. Oh, Becca, do you have anything on that?
I don't think so at the moment. I think one of the things just to keep in mind is once again, just being as upfront about the process and what that looks like to the survivor as possible. And once again, making sure that you're aware of what that survivor is looking for. But I think that's pretty straightforward. As an advocate, making sure that we're working with the attorney on the case, right? Because we have certain restrictions about what we can and can't do. So if there's an attorney, which we're highly recommending on these cases, making sure you're talking to them about what the survivor is looking for, because that's all of that's going to be determination about what they're going to be providing, what information is used where, and how that might be utilized moving forward. I will say we've had a couple of questions come in, but I'm going to hold off, just have those questions, continue to put them in the question box. We're going to hold off and ask those later. I just want to let you know that I am seeing them. We're just going to wait until we're done with the main part of the presentation, and then we will get those afterwards. So we're seeing you, and we'll answer as many of those as we can. So please keep submitting those as they're coming in.
Thanks again, Becca. And just so all of the audience knows, I too have many questions, and I like Becca said, we'll answer as many as we can at the end, but just always keep in mind that because these haven't been put in place yet, until we see how individual schools are interpreting these rules, there may be a lack of answers in precise hypothetical situations, because again, as we talked about last time, it isn't how we read these new rules and think they should be applied for survivors. It's how the school interprets them. Okay, let's move on. So the formal complaint launches the investigation. We talked about everything the school has to do at that point, all the notice they have to provide the parties. Here are some rules that they have to abide by when they're gathering the evidence. So whoever is the investigator, whoever's performing the investigation has to do or refrain from doing these things. Again, the school cannot access the personal records of either party maintained by a doctor, psychologist, etc., for the purpose of treatment without the consent of the party. This is always true. So precisely why they are including this really specific language is unclear to me, but as long as the records are kept for the purpose of treatment, which in most all of those cases will be, that party, the school can't just single-handedly request or receive those records. The party needs to give consent. The school has, throughout this investigation, an ongoing duty to allow the parties to prepare. I think what we're going to see here is this inviting, and that is to provide evidence during the investigation, to review evidence the other party has submitted, and to respond to evidence the other party has submitted. I think what we're going to see here is this duty is going to lengthen the duration of the investigation process, because if something new pops up that a party wants to give, even after they've perhaps given several statements, or they really want some time to look over something the other party gave and to respond, they have the right to do that, and they have to, and that's ongoing, which means anything that's submitted during the evidence collection can be reviewed and responded to, and they have to give that reasonable time to respond. So if that's 10 days every time, that's going to be a really lengthy process. But again, it's going to be to school to define what that looks like. Both parties have to be given an equal opportunity during the investigation, so this is even before the hearing, to present witnesses, evidence, and expert witnesses, and then that's going to be also true, obviously, during the hearing. This expert witnesses point, I think, is useful. So there are schools that say certain witnesses cannot, at this point, have said certain witnesses can't come to the hearing. I've had them say no to, an example would be a forensic nurse examiner. It's looking like here that the school has to allow expert witnesses if it's relevant. This one is a little bit interesting to me. The school cannot restrict the parties' rights to discuss the matters with others or outside the investigation context. So normally, or maybe not normally, but often, we will see some sort of instruction from the school saying, to the parties, hey, please don't discuss this outside of, what's going on here. Keep this confidential. What this rule is saying is that the school can't do that. The parties, again, have a right to free speech. They have a right to discuss the allegations against them or that they've made to people that aren't involved in the investigation. Obviously, this is a little bit worrisome, because if the survivor's worry is just that they're going to face backlash, or even just their reputation will be affected, they will be embarrassed if the respondent is talking about what happened, or just that they don't want it to come out that this event happened, and the respondent is going to have a right to do that, and not only a right to do that, but it's spelled out right to do that in the rules. We need to be aware of that, and so we can properly warn survivors. We need to provide both parties with sufficient time to prepare. Like I said, so written notice of the time, date, location, participants of all of these things, and time to prepare has to be given for all hearings, all interviews, and other meetings, which means the school cannot say to either party, we want to interview you tomorrow. If the party says no, that's not enough time, they're going to have to give them a sufficient time to prepare for all of those things. We kind of talked earlier about why that could be problematic when we talked about this, how this applies to that first initial meeting with the respondent, because obviously the more time that there is to prepare for these things, the more time to abuse the process. But of course, it does mean that these things cannot be sprung onto complainants either. It does mean that, again, it's another opportunity for the process to be drawn out in time. Hopefully, again, each of these things isn't 10 days, but it presumably would be deemed reasonable for a school to provide up to 10 days for each of those things, which is going to be a really long investigation process. So hopefully that's not the case. And then each party has to be given a meaningful opportunity to respond to evidence after it's provided. I think this, and then the information in their response must be allowed in the hearing. So what that means is that what they're trying to make sure can happen here is if the complainant gives a statement, not only does the respondent have the right to take time to provide a meaningful response, right? So he doesn't have to respond it. They don't have to respond in the very next day. They have time to prepare that response, make sure it's meaningful. Meaningful is probably also going to be used to say that they can add new evidence in that response to respond to the statement. And so that's where this, it must be allowed in the hearing comes in. The argument is going to be that if a party has to respond to an allegation or to a statement by the other party during the investigation, and they have to bring new evidence or new information forth in order to respond to that, then that has to be included in the hearing. The school can't say that's not relevant. How that plays out remains to be seen, I'm sorry. And then finally, we saw this earlier, but the parties and their advisors have the right to inspect and review the evidence obtained by the school if it's directly related to the allegations. That is, that directly related to the allegations is probably the same as that relevance requirement. And so again, that certain evidence requirement. So the school is going to be able to determine which pieces of evidence are directly related to the allegations or are relevant, and then they're going to give that right to inspect and review. Again, not that right to copies or any specific means of providing that evidence. Becca?
All right, so I wanted to highlight there that the psychologist and doctor records can be obtained, so with the consent of the parties. So it's not that it would never be able to be used, so just kind of keep that in mind. With that though, it's important to know what they may or may not want entered and what that release information would look like, how extensive or not extensive it is. So if a survivor or a respondent has been seeing a counselor for a long time, what the constraints of that release is. So just very important to note that it's not that it can't ever be used. So it's possible though that could help protect those records and certain doctors or psychologists results that maybe they've been asked to provide and don't necessarily want to provide. So just kind of keep that in mind. I also wanted to note too that although there is no restriction on the right to discuss, the school cannot restrict the parties' rights to discuss the matter. That does not mean that there can't be lawsuits based upon that, right? So there's still a possibility of defamation or libel suits. So just being careful about when you're talking with a survivor, absolutely they can discuss it and they can talk about it. But like I said, that doesn't protect them against lawsuits if someone is looking to do that. And then the last thing I mentioned here is that there's still external procedures that might be going on. So are there no contact restrictions, protection orders, those kind of pieces that interact with this that either restricts the parties' right to discuss or have someone discuss it with them. So if it's a witness or someone like that, just keeping that in mind as well, that we're kind of focusing on Title IX, but we want to make sure and remind you not to forget about the other laws that are going on too, right? And the other things that are happening outside of Title IX that are going to impact Title IX.
Thanks, Becca. And that reminds me of one point I forgot to make here, that the schools cannot restrict the rights to discuss. Presumably what that leaves open is that the parties can even discuss the matter with witnesses, which is problematic for all of the reasons we know, right? Intimidation and altering statements and, kind of working together with witnesses rather than letting the witness be a neutral. witness to the proceedings. I don't think there's anything holding the school back from including a requirement that witnesses are not intimidated or otherwise harassed or by either party, but I think it's going to be more unlikely, less often we're going to see this requirement that parties can't speak to witnesses during the investigation altogether because of this rule. All right, let's move on. So after the gathering of evidence, there's going to be 2 reports made by the investigator. Most schools already do this as well. There will be a preliminary report and then a final report. Here's that 10-day matter again. So once the preliminary report is finished, it needs to be provided to both parties in writing, and then both parties are going to get 10 days to respond to that report in writing. And the school, or so the investigator, must consider that response before writing the final report. So what this means is if the preliminary report is put out, both parties respond, 10 days later they file their responses, and then the next day final report comes out and it's identical to the preliminary report. Well, then both parties are going to have grounds to say, whoa, you obviously didn't consider responses. You didn't consider what I said in my response because you didn't even change the report. So it's likely that we're going to see some discussion in the final report about the responses, so how the school did consider them, what they thought of them, rather than just including copies of those responses because of this requirement. The final report, and then also this probably means, and I guess it remains to be seen, but a lot of schools have the rule that at this point, so once the preliminary report is done and there's an opportunity to respond, a lot of schools say you can't present new evidence at this point, right? You can respond, you can make any corrections or provide context for what's in the preliminary report before the final report is issued, but you can't provide new information. It doesn't say that here. And so it may mean that not only is that allowed, but that it has to be considered, which again is going to lengthen this investigation. After that, the final report has to be provided to the parties in writing at least 10 days before the hearing. Again, even at a minimum, this is showing us that if the preliminary report is issued and there's 10 days to respond, and then there's 10 days from that to the hearing, that's a minimum of 20 days, even after the investigation is finished. Becca?
So with this, it's I think I don't really have too much to add here because I think it's pretty straightforward for the most part, just in terms of making sure to explain those differences, right? I think one of the things that I've noticed in regards to these regulations as opposed to prior is that there seems to be a lot more steps involved, and not to say there weren't steps involved that the schools were enacting themselves and things like that, but in terms of preliminary reports versus final reports versus hearings, so just making sure that everyone is very aware of that. And you'll notice here that they have 10 days to respond to that preliminary report, and then the final report provided to parties at least 10 days before the hearing. So that's at least 20 days. So we're looking at least a month before we are getting to a hearing, and that is a very rapid in terms of a criminal procedure, but can feel very slow in a school context, right? So we could be most of the way through a semester or a quarter before before a school is able to even get to a hearing, and that's with everyone moving very quickly and right on these deadlines. And so kind of thinking through that and what that looks like. So if someone is looking to make a report, move forward with a formal complaint, that timing piece is going to be really important.
Thanks, Becca. And yeah, I would say that I'm sure most of you know that previously there was some guidance on, the schools should do everything they can to make this whole process wrap up in 60 days. That doesn't appear in the new rules, and I would think that's going to be quite unlikely in most cases, just given all of the new steps the new unfamiliar steps the schools are going to have to embark upon, add to their policies, and then all of these chances to respond that appear throughout the process. All right, so here's a point where we're going to talk a little bit about the difference between K-12 and campus rights to survivors. Now, as Camille stated earlier, most of this presentation, all of this presentation for the most part, has been based upon the presumption that some kind of campus sexual assault occurred. So the sexual harassment occurred on a institution, post-secondary institution's campus, or through their students. We also know, however, that sexual harassment does occur in the K-12 context. Title IX protects those students. And if any of you have worked in the K-12 context in the Title IX world, you know that it is absolutely different at every school, absolutely different than the campus process, and that it is often a situation where no one quite knows what to do when. The new rules do not prescribe as many definitive requirements for the K-12 context as they do the campus context, which I think obviously invites us to continue upon this path of K-12 institutions kind of being in the dark about how they should approach these things. I think we cite to the new rules in the K-12 context, and we can put out some guidance next week specific to K-12, but just keep in mind that it is still going to look different, and it is still going to be less prescriptive. One huge difference is that in the K-12 concept, the school can decide to hold a Title IX hearing, but they don't have to. They have no obligation to. All they have to allow for is that the parties have a right to submit relevant questions to each other before a decision is made. So before the school finds that Title IX, that some sort of sexual harassment has occurred, or that a school has been, or a student has been discriminated against under Title IX, they have to provide both parties the chance to ask each other these written questions. But again, that doesn't have to be in some sort of sit-down hearing. These questions, of course, cannot be about prior sex acts. We'll talk about that rule in regard to the campus hearings in just a minute, but obviously, this means that when we say parties in the K-12 context, because we're dealing with minors for the most part, this also means that parents have that right. So parents can provide these relevant questions to each other, to the other party, before the school administration makes a decision. What precisely that's going to look like in individual schools remains to be seen, and is an interesting, I think will be an interesting point in the process we should keep an eye on. But in the campus realm, in the college realm, institutions have to hold a live hearing. What is a live hearing? That does not mean necessarily that everyone has to sit around a big table in the same room. One or both parties can still request that they appear at this hearing in separate rooms or remotely by video. For example, right now during the pandemic, all Title IX hearings have been conducted by video, and that that can continue to happen under these rules. But live hearing does mean that it is a hearing in which the decision makers are at that time listening to both parties tell their stories directly to those decision makers. There's not a recording of a party giving a statement that is then provided because they don't want to or cannot attend that hearing. They both have the opportunity to attend that hearing and directly speak to the decision makers and directly answer questions from those decision makers. The advisors to the parties must be permitted to cross-examine the other parties and witnesses because the parties cannot directly cross-examine each other. They cannot directly communicate with one another. We're going to talk about that in just a second. But also in these live hearings, the school has to record them somehow. That is, an audio recording or provide a written transcript of everything that was said. Again, available for the parties to inspect and review, not available for them to have copies of, not available for them to have temporary access to the audio file. So it may be true that the school demands that the parties go sit in the Title IX office and listen to that recording and take notes. And if they wanted to do that, they could. There's nothing here saying they can't provide that audio, say by email, but they don't have to. All right, let's talk about cross-examination real quick. I know that this is one of the most questionable or contentious pieces of the new rule, and certainly it's one that we will just have to see how it plays out. It is one that we will have a lot of specific guidance for advocates next week. But this week, as we discuss what the rule says, it says this: parties have a right to cross-examine the other party and witnesses in a hearing. This has pretty much been true. The cross-examination must be conducted by the party's advisor. This is different. As you probably all know, previously in these hearings, advisors weren't allowed to do much of anything. They weren't allowed to speak in the hearings other than to talk, quietly to advise their own client. Here, they're actively participating in the hearing because they are the one cross-examining, so questioning the other witnesses and other party. Again, because they can't directly question each other, which was permitted and did occur at some schools under the guidance. If a party does not have an advisor who, and under the rules, can be an attorney or not, we're going to take the perspective, I think, that advisor absolutely needs to be an attorney, and we'll talk about why next week. But if that party doesn't have an advisor, the school will give them an advisor they call advisor of the school's choice. The purpose of that person, however, is only to ask those cross-examination questions. So what that looks like is that let's say the complainant, the survivor, does not have an advisor but wants to ask some questions to the respondent during the hearing. This advisor of the school's choice will show up and come into the room to ask these questions. The complainant will hand over a list of questions that they want to ask of this respondent, and this other person will ask the complainant's questions to the respondent. There is no requirement that this person be a lawyer or a specific school employee under the rules. It can be anyone. There's no requirement that they obtain specific training. There's no requirement that they consult with, or even really any indication that it is permitted that they consult with the party before the hearing or any time before they ask these questions. And so there's no advising by this advisor, which is problematic in that for the school to call it the advisor of the school's choice, but the advisor to not be allowed to provide any advice because their only role is to ask these questions to the other party. We need to absolutely warn survivors that if they are receiving this advisor of the school's choice, that person is not on their side, not going to give them advice. And if they do give them advice, they haven't been trained in what advice they should give. It could be an undergrad student younger than the complainant with less experience in Title IX than the complainant. Again, their only job is to read questions written by one party to the other during the hearing. What are the rules for these cross-examination questions? So they're limited. The party, you can't just ask anything. Like in a criminal proceeding, you'll see attorneys kind of creatively using cross-examination to tell a story, to point things out. Here it's going to be limited. The questions have to challenge the other party's denials or allegations. The question that remains here is, so if something isn't explicitly in that other party's statements that they've already given, or they haven't already said something specific about that during the hearing that day, does that mean that it's off limits? Because that might mean that, for instance, a witness said, that they had a discussion with the respondent, or they knew something to be true about the respondent, they saw something, and it may be true that under this really limited rule about the questions, it won't be permitted that the question be asked about that, because it isn't specifically denied by that party or alleged by that party in the investigation materials. So we'll see how that plays out. Again, it has to be relevant. And so here's how it's going to work. The advisor, so hopefully the attorney of the party will ask a question. And there will be a pause, and the panel member or whomever will decide if that question is relevant in the moment. And they will say, yes, go ahead, or no. And then the question can be answered by the responding party, whoever's answering the question, if the decision maker says, yes, it's relevant. This is a slow, wonky process. So we need to warn survivors about that. Cross-examination questions about the sexual history of either party, but most importantly of survivors, cannot be asked unless the other party is trying to show that someone other than the respondent committed the harassment. So maybe that the complainant misidentified the person that sexually assaulted them, or regarding consent. Well, we know it to be true that a very common defense, particularly to non-consensual sexual contact, is that there was consent. And so because questions about consent can be asked, and those can be asked involving prior sexual history, we need to warn survivors that respondents can probably ask about other times the two of them engaged in sex. Hopefully not about their history with others, though that is not spelled out here. They call it rape shield protections, but they, in reality, what the rules prescribe here are very much more limited than rape shield protections that we might see in the criminal context or other contexts. Cross-examination, number one, it's probably never going to be in the best interest of a party to have an advisor of the school's choice, because they're not advising, and that is problematic in that that word advisor is going to cause parties to assume that this person will be at least helpful, and there's no requirement that they are. And so we need to really warn, we need to really get that message out. Also, again, we'll provide further advice next week, but these cross-examination questions, because of all of these real limited windows, someone trained in cross-examination needs to be performing this task. That means this advisor, if they're going to be performing cross-examination questions, needs to be an attorney. Attorneys are trained in cross-examination. Others aren't. Advocates aren't. Other supporters aren't. And to put someone in the position of doing something that they haven't been specifically trained in doing, that could potentially put that survivor at more risk is probably not a risk we want to take. Becca, do you have anything to add here? I know we're running close to time, so I want to get through the last few pieces here. But Becca, do you have anything to add here?
No, I would, for the sake of time, I'm just going to say, just go ahead and work through that. I know we have some questions coming in that we're going to do our best to get to, and then we can also talk more about advocates next week. But you go ahead and continue, so that way we can make sure and get through the content today.
Thanks. All right. Again, obviously, no one can be. This is interesting because no one can be forced to engage in cross-examination or the hearing itself. On its face, that's fine, except the question is this. So the rule says this: if a party does not appear at the hearing or does not answer cross-examination questions in the hearing, the party's statements or their witness statements, if they're a witness, are excluded. That means decision makers can only evaluate evidence that does not include statements by that party or witness. So what we've seen before is this means, for example, if a witness doesn't show up to answer questions and can be subjected to cross-examination, then oftentimes the school will say the panel can't consider that witness statement. That makes sense. What is problematic here is this. Does that mean that if a respondent comes to the hearing or doesn't, but if they come and don't answer the cross-examination questions, does that mean that their statements are excluded? Because what that would mean then is that decision makers can't look at their statements given during the investigation to assess their credibility. Are there inconsistencies in there from what they say during the hearing? Are there denials in there that the complainant is able to show is true? Or do they tell multiple stories? If their statements given during the investigation are excluded, it seems as though by choosing not to answer cross-examination questions, respondents can use this as an opportunity to keep out previous statements they think might be harmful to them. That's problematic. And so we hope that's not the way these rules are read, but I also at the same time think that's how we're going to see advocates for respondents suggesting they be read. Okay. Again, here, the decision makers have to be trained. We don't see any focus here on survivors or trauma, so that's obviously problematic. In the decision about responsibility, there are some really specific things that the findings that the decision makers have to make. I think what's really important here is that they have to, again, be able to apply some sort of fact in the allegation to the specific policy language that was violated. So if they're not able to do that, then they're not going to be able to find responsibility. And it can be even a minor point, but if they can't make those matches, they're going to have to, which is another reason why an attorney should be used. And so the attorney can help the complainant submit evidence in a way that shows the decision makers how every element of a policy was violated. And then the decision makers can use that language in the written decision. The written decision also has to tell the respondent whether or not only what disciplinary sanctions are given, if any, but whether and why remedies were given to the complainant. So the school has to explain themselves in what remedies they gave to the complainant and how exactly that remedy will restore or preserve equal access to education. So if the school can't come up with a specific way that remedy does that, they're not going to be able to provide it for the complainant. We've talked at length about appeals, so I'm not going to go into this other than to say, again, that there's 2 points at which this can occur, and that, which is new, and that there could be an effect on the effective date of sanctions or remedies, because the rule says that there's the written decision about the appeal is the final determination by the school regarding responsibility. I think it could be argued that the school can't make sanctions or remedies effective after the finding of responsibility until after the appeal decision has been written. And finally, this is a really important point. Retaliation is kind of defined in the new rule and a little bit differently than we've seen before. Again, we're going to see this theme of free speech. So free speech can never be retaliation. So if a respondent can argue that whatever they were doing, saying, was not intimidation, but they were just exercising the right to free speech, schools are not going to be able to charge them with retaliating, call that retaliating conduct. And schools are probably going to be afraid to do so because of that rule. So this other piece is interesting in that a school can charge a school can charge a student with code of conduct violations for things that are related to, but not specifically, sexual harassment. So related to allegations of sexual harassment, but not exactly that. But if they do so, the student can allege that in of itself, that school's decision to charge them with these additional violations or with code of conduct violations because they couldn't find enough evidence to charge them with sexual harassment violations, in of itself could be retaliation committed by the school. So that may, again, make the school less likely to pursue those options. And finally, schools can punish false statements made during the process made in bad faith, but they can't decide that something was made in bad faith just because the respondent was found responsible or not responsible. And again, First Amendment protected speech, absolutely never evaluation. Only interesting thing in record keeping is that each school, again, is going to have their own policy, but I think it's interesting here that schools, in the event that there is only a report filed but not a formal complaint, schools are required to keep record of who the complainant was, because they have to keep record of any supportive measures given to that complainant. And they also have to, keep records about how they responded to a specific complaint. It seems to leave room for the possibility that if it's only a report and not a formal complaint, there does not need to be mention of the respondent by name whatsoever, because they have to keep record of these materials and these supportive measures, but because the respondent hasn't been notified at that time, the respondent isn't necessarily going to appear in any of those records. All right, we'll talk more about this next week. So right now I'm going to say questions for the last 25 minutes.
All right, yes, we've had several questions come in. I do want to say that if we don't get to your question, I will make sure and jot it down, and we can make sure and address that at our next webinar. So the first one is, if a survivor tells their on-campus advocate about their fear of physical danger, can the advocate report that to the Title IX investigator, or does it have to come from the student directly to the Title IX investigator? Also, does it have to come from the survivor in writing?
I think it depends on when we're talking about in the process. So we know it to be true that a report can be made either by the survivor or anyone with knowledge of instances of sexual harassment, which could obviously include that description of the fear of physical safety. But if it's in order to launch the investigation, that formal complaint, then that information is going to need to come from the survivor. And obviously, I think that the concern being, can I as an advocate tell the school that? That's going to be after a discussion with the survivor about whether they wish you, as their advocate would do that. And again, that's only going to be able to happen prior to there having been a formal complaint filed, because at that point, that information is going to need, whatever information is going to be used to launch that formal complaint is going to need to come directly from the complainant.
Great. The next question came in while we were discussing confidentiality and what can and can't be included. So this question is, does this include the advocate's record to be protected?
No. There is no statement that advocates' records are privileged. The advocates share some specific privilege while at the practice of an advocate is to be confidential. There is no precise privilege under the federal law or regulation here. However, it presumably the complainant is going to be the one supplying relevant information to the school that they want considered, and so the complainant should simply not submit that. And I would hope it would be very rare for that to be asked for by either the school or the respondent. And I would assume that, again, that complainant's going to need an attorney but they're going to make some arguments about to use that free speech theme to their advantage. We have a right to free speech too. I have a right to talk to my advisor free of the fear of harassment or something along those lines. So, but no, not expressly.
Great, thanks. So we're seeing a lot of language around conflict of interest pertaining to decision makers. What about advisors? I'm concerned respondents will utilize faculty/staff with power over the reporting party as an advisor. Is this possible under these regs?
I'm not exactly sure what the question is. If the question is who can the school put in position of a advisor in the event that they don't, the party doesn't have one. Yes, so there's no real requirements for who that advisor person can be. So sure, I think we can worry that it can absolutely be some sort of staff member or someone else from the school that we would not want to be involved. Yes, they are going to have to be free from conflicts, but that's demonstrable conflicts, which again is why I think we want to avoid that ever occurring. And instead, that person needs to have an attorney acting as their advisor.
Great. Next question, how does this keep confidentiality if people can talk to anyone about the investigation? Couldn't this impede the victim's safety?
Would it impede safety? Absolutely. But you know, their argument in response would be, again, we have a right to free speech. If someone is saying that I sexually assaulted them and I want to tell other people that this is happening to me and that I think it's unfair, I can do that. We are, of course, going to make the argument that that absolutely is going to make survivors feel unsafe and therefore less likely to file formal complaints. I think the response we're going to get is, well, if they don't want to file a formal complaint, you know, we're not going to restrict the access to free speech to the respondent. If they don't want to file a formal complaint, they can give a report and we'll give them supportive measures. That's the best we can do. And I think that's what the response is going to be. I think you're on the right track. That's one of the many reasons why that is so problematic. But again, these new rules are really holding the right to free speech above safety and other considerations.
This next one's more of a comment than a question, so I don't think the response needed at this point, but I just wanted to share, with social media, that could be a horrible thing to be able to discuss the investigation. So, agreed.
Yes, and keep in mind that all digital words is free speech as well, and so, yep.
So this was asked before you talked about retaliation. So there's a question about, are there no longer rules barring retaliation? So was there anything you wanted to add to what you already talked about in terms of retaliation?
Yeah, so there's no real new definition of retaliation, and you both parties can still argue that you know, retaliation has occurred, but again, it's going to be protected by this really strong right to free speech. So probably, unless that retaliatory conduct is you know, causes physical violence or is otherwise really severe, the school is not going to charge retaliation.
Next question, why would they drag this process out longer than it needs to be 20 days?
I can't even begin to answer why would they questions. I think the argument is this, we need to give respondents a more meaningful due process, and that process has to be as long as it takes to make sure we can exercise all of our rights. And they're going to say not respondents due process, they're going to say all parties due.
Kendra, if I can just add to that, I wanted to make sure and note, so there are some that have certain set timelines and there are other things that don't. So depending upon how the school responds to things, access to witnesses, access to information. There's some things that have very set times, but the majority of things actually do not have set time limits other than promptly reasonable. So just to kind of make sure and reiterate that, there's only a couple things that are specifically mentioned in terms of a specific time frame.
Right, and that, I think it's also important then too, this is really where individual school policies are going to differ really widely here. If we do have schools saying 10 days between every response, every submission of everything, that's a longer process than a school that says, we think a reasonable time is a day here or 2 days here, but then we'll abide by the 10 days where the rule prescribes it. That's going to, lessen that. That's going to shorten that process time, but I think we're going to see both extremes and then a lot of mix in the middle, and it's going to be probably one of the first things we need to look at when looking at a school policy, because there's so many different times throughout the policy, throughout the procedure, that there will be a time frame implemented by the school, that we need to look at each of those, because they may be different every time. I mean, not every time, they'll always be, they may be different at every point of that process.
Can schools make a requirement cross-examination questions are provided prior to questioning to be checked for adherence to cross-examination question requirements?
Could they? Maybe. But I would say they probably won't, because the rule specifically prescribes for this process where the question is asked, there's a response about whether or not it can be answered, and then it is answered. So I think that's how they deal with that.
Can you give an example of a time a witness won't be permitted to speak about certain subject?
Sure. So anytime the school says that whatever the witness is going to talk about is not directly, quote unquote, directly related to the allegations, then arguably the school can say they can't talk about that. What would that be? It might be something about a comment the respondent made at a party about a different female at that party, or something he said earlier in the day, that, if we stretched and we thought, well, that might show he's more apt to, his intentions for the night were this or this. We may think so, but if the school says, no, that's too far of a stretch, that witness is not going to be allowed to say that. And if the, again, if the respondent decides not to testify, so not to answer cross-examination questions, and a witness is coming to talk about things that would have only appeared in that respondent's statement. So for instance, the respondent has a statement that says he had a discussion with this witness, and the attorney may want to cross-examine that witness about that discussion. If the witness doesn't provide for that discussion in their statement they've already given, it only applies in the respondent's statement, then arguably questions about that cannot be asked, because any information only available in the respondent's statement cannot be considered if they don't answer the cross-examination questions. Again, that is a kind of worst case scenario interpretation. We are hopeful that that's not how the new rules are interpreted by schools, but it absolutely could be.
Great. Can we keep the mandatory reporter requirement under the Code of Conduct to capture cases where there is no formal complaint?
Can you say that again?
Sure. Can we keep the mandatory reporter requirement under the Code of Conduct to capture cases where there is no formal complaint?
Perhaps, yes. All of these allegations could arguably be addressed under some other disciplinary measure, Code of Conduct being one, Title VII being one if it's an employee. However, there's no requirement that language about mandatory reporters be included in that either. And so that's still going to vary school by school.
If an advocate is protected under licensure, like an LISW, would records be protected?
Again, probably not, because it's not recognized by the regulations that federally recognized as a privilege. I think that would be the argument if need be, but I don't think that this is the venue we're going to have to worry about advocate records being used. I think that's going to be more likely in a court context.
So some of this we actually are going to address next week, but we have a little bit of time. Kendra, if you wanted to address any of this now, if an advocate is the only support person / advisor at the hearing and is responsible for direct cross-examination, what are the implications and how does this change the role of an advocate?
So as an agency, we're going to say an advocate cannot conduct cross-examination. They've not been trained on it. And the ramifications are that they could be responsible for the unauthorized practice of law by doing so. If you are in a situation as an advocate where you are the only support person, you need to find a way to get representation for that client. Not only could you be held responsible for the unauthorized practice of law, so too arguably could the school by having the requirement that that happen. I think we are certainly going to see litigation in this realm, probably sooner than later, and we're going to see probably different pieces of guidance on this. I think there is an argument, of course, we're going to hear that, some support is better than no support. So, I have no choice but to do this. That is not true. This is something that is not, it should not be a burden put on advocates. And an advocate's responsibility in that instance is to secure legal representation or to help secure legal representation for that client.
Which leads actually very nicely to the last question that we currently have today. Where are survivors going to find an attorney to ask these questions or cross-examine?
Hey, that's a great question. So, there's no requirement in the rule that the school has to provide an attorney, right? Or access to an attorney or instructions on how to get an attorney. Ohio advocates should contact us. And we have our clinic attorneys and we also have our panel attorneys who we train on handling Title IX cases. If for any reason that isn't your route you take, I do believe that even other community legal aid organizations are going to have no choice but to be learning how to do these things because there is going to be an obvious increase in need for attorneys trained in and familiar with Title IX proceedings to represent survivors' interests. So it is my hope that free legal services, community free legal services will be also available to do this. And hopefully we will be able to train more and more attorneys around the state to be able to do this too, so that the OAESV can provide experienced attorneys as well at no cost of survivors. But you're identifying one of the central issues here, right? Which is that certain survivors have access to certain resources that others don't. And there is an inherent unfairness in the requirement that cross-examination occur, but without the requirement that the school provide that free legal access.
I also wanted to make sure and mention, because OAESV cannot handle all of the types that are covered under Title IX, such as domestic violence or dating violence cases. that ODVN has a similar program to ours as well. So if it's a domestic violence or dating violence situation, you might be able to reach out and get some support from them as well if there's no sexual violence involved. So just wanted to bring that to everyone's attention as well. Both OAESV and ODVN have very similar programs in that respect, and in terms of how you apply as well. So happy to chat more about that offline, but wanted to make sure and mention ODVN as well on that, because Title IX doesn't just cover sexual violence.
Yep, what Becca said. But really, it is going to be I mean, we as an agency have always advocated for best practices that a survivor in this context not only be represented by an attorney, but be represented by an attorney from the very beginning. But that is of most importance now, because these new regulations include so many legal ramifications and unanswered questions that we haven't encountered before. So the best thing an advocate can do, I think, and advocates are going to be needed as well. Advocates are going to absolutely be needed to walk survivors through all of this new information, and supporting them in decision making. But I think it's going to need to be a tag team effort of an attorney and an advocate. So as an advocate, please consider making one of the very first steps you take upon receiving a case where there may be a Title IX complaint, doing just that and trying to find that legal representation, or at least a legal consultation for that survivor.
So that is all the questions that we have that's come in for today. So Kendra, if you want to wrap it up for us, and we're actually on time today, which is very exciting.
Thanks, everyone. If you have any other questions before next week, you can always reach out to us, but please come back next week. I think there's going to be some more really concrete materials and information you can use that are practice specific. Thanks.
I just want to jump in real fast, Kendra. So next week we are not be meeting. We're going to be meeting on the 1st. This coming Monday is a holiday, so we'll be meeting in 2 weeks, same time, 1 to 3 on June 1st. Thank you all so much for joining us.